Hi, everybody. I want to welcome you to the Resident and Family Support Council meeting that is held by the Illinois Long-Term Care Ombudsman Program. My name is Lee Moriarty, and I'm the Deputy State Long-Term Care Ombudsman. We host these meetings on the second and the fourth Tuesday of every month at 3 o'clock. And always remember that the link that you use to get into the meeting today is the same link that you can use to get into all of our meetings. And please feel free to share your invite with anyone and everyone. After these meetings, many times I get emails from people saying, please add me to the list. I got this email from my friend who forwarded this on to me, and I'd like to get onto the email invites. I love to get those. And so that's what I do. I add you to the email invites, and then you can get them in your own email inbox. I want to encourage everybody to share this information with anybody at all who you think may be interested in any of the topics that we have. And to see what those topics are, you can actually go to our website, which is all you need to do is Google Illinois Long-Term Care Ombudsman, and the page should come up right away. But I will make sure I put the link into the chat as well. Our person who typically does this could not make our meeting today, so I'll be putting all the links into the chat for everybody. And then also, if you can't make the meeting, and especially for today's topic, I had a couple of people say, darn, I can't make it today. Are you going to be recording it? And so, yes, we do. We record these and we put them on our YouTube channel. So it will be on the YouTube channel, so you can access this at any time. And today's information that we're talking about is really important information because this is going to be the rules, the regulations, what the state is saying we need to be doing in regards to this aging path and the aging network. There's a lot that has happened in the spring session. And so to talk about that, we've got Jessica Belsley, who is the ombudsman specialist. So she works with the ombudsman program and does a lot of work around legislation, a lot of work around our data input. She's a phenomenal member to our team, so we're really happy to have her join us. And then we also have Karen Coppy joining us, who is a legal assistance developer for the Department on Aging. And she has been a part of our work group and a very valuable member of our team, helping us making sure that the topics that we bring to all of you are important topics. And just before we get into the topic, because I mentioned it, if you have any ideas for any topics that you would like to see or any questions that you have that might not be related to this, please put that in the chat because that's how we decide on a lot of our topics. The work group monitors that. We take input from people. We get emails from people. And so that's how we decide on what the topics are going to be based upon what your interests are. So with that being said, I am going to go and hand the baton to Jessica, who will be controlling the slides, and we'll let Jessica and Karen start sharing with us everything that's been going on in legislation. Welcome, Jess, and welcome, Karen. Thank you for doing this for us today.
Thanks, Lee.
Happy to be here.
We're excited that you can. And we know that there's a lot going on, and not everybody might understand the whole legislative process. So I'm hoping that you can share some information with us as well to kind of help put us on that path to set us up for what exactly we need to do in order to have this important legislation get passed.
We'll be happy to do that. I just wanted everybody to be aware of this slide. This is the mission of the Department on Aging. We are a network-driven organization, and all of our programs depend on the very strong collaborative process that we have with local providers. And I put this in the slides because our last Resident and Family Support Council, we had a colleague, Pernell Borders, come and talk about all the different ways the aging network is able to interact and provide support for older Illinoisans and their caregivers.
Great.
On to you, Jess.
Karen, are you covering the slide and I'm just moving, or were you wanting me to talk? Sorry.
I thought we would just have a brief conversation. I'm an attorney by training, and in my career at the Department on Aging, I've actually been involved with legislation from a variety of perspectives, a little bit different than what Jessica has. I've been a person behind the scenes helping draft language for our programs and reviewing them, but Jessica has been involved at more of the front end process about the advocacy. And laws are important primarily so that we have security and predictability, which leads to better public health, safety, and welfare outcomes. But if you'd like to talk a little bit about the advocacy aspect to legislation, that would be great, Jessica.
Thanks, Karen. Yeah, one of the things that always makes me laugh when I think about the fact that I'm doing this work is prior to becoming an ombudsman, I actually have a biology degree, and right out of college, I took a job at the Legislative Research Unit, and there, one of my job was to research the science-related topics that legislators have. And we called it the LRU. It has a new name now. It's still around. There's a research arm for the state legislature, but never in a million years did I dream that I'd be doing this at this point in time in my career. But within the ombudsman program, one of the duties of the state ombudsman and of the ombudsman program is to do systemic advocacy work. And sometimes that looks like working with on behalf of a group of residents, maybe within a chain of nursing homes. But it also can look like systemic advocacy work in terms of working to change laws, policies, regulations. So for the Ombudsman program, for the initiatives that we'll be talking about a little bit later, what happens is maybe we see the same type of issue come up over and over again, or maybe a resident or the resident's family member brings a concern to us that really there's no way to fix it without making a change to the law. Sometimes it's a regional ombudsman bringing an issue to us. So we get our ideas from a variety of different sources, but oftentimes they're issues that ombudsmen have tried to change, tried to resolve things on behalf of residents, and we hit these roadblocks because of the way the law is written. And so that's where our brainstorming usually starts from, in terms of, next legislative season, what do we want to try and tackle? What are our initiatives going to be for next year? So for us at the state office, that starts with a conversation, the state ombudsman asking other parties for their ideas, some discussion internally. We bring in our legislative assistants to have from the Department on Aging to have conversation with them. And then we're also talking to our sister agencies like the Illinois Department of Public Health, if it's an initiative that would affect part of what they do, where sometimes it's healthcare and family services. So these ideas don't just come out of thin air, but there's a lot of thought and a lot of research that often goes behind where we are before we even get these, before we're talking to a legislator about them even.
And this is a picture of here in downtown Springfield. This is the Illinois State Capitol. And I would like to put a plug for tourism. If you're out and about in Springfield, we have one of the oldest capitals in the nation, and it is subject to quite a bit of restoration work. And in the link in the chat, I've put some information so that you can see some of the interior artwork. We have historical preservation going on, but also there's been a strong commitment to supporting the art community. And there's all sorts of things. If you're from the central Illinois area, like I am, this is one of the many places that you went as a school child for the tourist activities about learning about civics education. And you can move on to the next slide.
Well, and also if I can say, Karen, we do have the state fair that will be coming up, and know that the Department on Aging, we always have a table there, as well as the Ombudsman program. So if anybody's thinking about going to Springfield for the state fair, I hear it's a great event. I've never been. I will be going this year for the first time, and I'm excited to see what it's all about, as well as get a lot of information about what's going on in the state, including the Ombudsman program. So.
Well, come find me, and I will give you the skinny and all my favorite places to go eat during stair food for fried food on the stick, and combination lemon orange shake-ups.
Ooh,
so in Illinois,
definitely, Karen. Thank you.
Okay. In Illinois, we have a two-chamber structure. We have the Senate consisting of 59 individuals, and they, align with the Democratic and Republican political parties. And then as we move to the next slide, you will see that we have the House of Representatives, which is a much larger chamber. They have 118 members. And again, it is a split between the Democrats and the Republicans. And when we go to the very next slide, you will see this is where you can do research. This is the website for the Illinois General Assembly. And it looks very complicated, but when you slow down and you actually stop, and I don't know whether Jess is able to make the magic happen, but you can see on the left, you're looking at legislation and laws, and they are at different stages. There are bills and resolutions. When they are enacted, meaning signed by the governor, they become public acts. And then at the top on the right-hand side, eventually the Legislative Reference Bureau, the counterpart to Jessica's former employment home, the Legislative Reference Unit, they are codified and put into the Illinois compiled statutes.
So this is the place when where I use like, oh, I heard about this bill. I'm going to come jump here. I'm going to type in the bill number and I'm going to see what's going on with it. So one of the bills that we had introduced earlier, and it's, we'll talk about it a little bit later. It was House Bill 5012. So you can type on the left-hand side here, HB 5012 and click go. And what that's going to do is that'll take you to where that bill is sitting. So you'll have a short description here. So this is the short description that the Legislative Reference Bureau gave it was the nursing facility residency. You can see this is the House sponsor. And then if you scroll down, there's a synopsis is introduced. And then you can see the action that took place. So this bill, we got it out of Human Services, then there was an amendment. There was a House floor amendment. Anyway, we ended up deciding not to run this language. So at the end of session, it got re-referred to Rules Committee. That said, one of the things that it's important to point out, and Karen, I don't remember if it's later in our slides or not, so I'll just touch it here, is if a bill is amended, the short description does not get updated. And a good example of that is the language that was in House Bill 5012, actually now in House Bill 5051. But if we look at the short description, it says it's about pertussis, which is whooping cough. This bill that started as a pertussis Vaccine Act bill has these amendments on here. And if we come down to Senate Floor Amendment 2 and read, it says replaces everything after the enacting clause. And now it's turned into what is now the discharge language that we had sitting in the other bill. So it's really important when you're using this website that you don't just read this short description, that you actually scroll down and see what action has taken place and what the most current language is, because sometimes it's surprising what you think you're looking at isn't actually what the language is that's the most current language in that bill.
And
okay,
while
Go ahead.
and while the language in these synopses is intended to be descriptive, the staff at the Legislative Reference Bureau is required to present that information in a certain format. And with all sorts of amendments that can come along during the legislative process, at the end of the day, you need to remember not just to rely on skimming, the short description or the synopsis. You actually have to go and look at the actual text of the language. And an example I will give you is every year when we get ready to change over, there is a budget bill. Sometimes you'll hear it shorthand called a BIMP. And while the focus of that is on financial aspects for all the government bodies, sometimes there is substantive information put in there. And I just gave the part of the agency that I work for, Older American Services, in the Division of Home and Community Services, a heads up about the creation of a new portal. I did not expect that to be part of the budget implementation bill. So legislation, you just never know how it's going to work until you actually read all the details. And the other arrow on this page is at the bottom. Legislation, there's a priority. The highest law of the land is the Constitution, and then you have enacted laws, and public bodies need to add details, and they do that in the form of administrative rules. And again, this is a public process, so rules are published in the Illinois Register, and eventually they are codified, and you can click on the Administrative Rules button, and it will take you to the Illinois Administrative Code. Illinois runs on a 2-year cycle. So we're currently in the 103rd General Assembly. And over this 2 years, there was a lot of bills introduced, just shy of 10,000. And in this session, 466 bills have passed both chambers. And at this point, we're done with the session. And so all the work from the General Assembly is now moving over to the governor's office. And I'd like to thank Mary M. in the chat for saying she can help explain the legislative process. Many of us learned to sing the bill song, and she put that in. So thanks for that fun flashback. But when a bill has passed both houses, they get it prepared and they send it over to the governor's office. And according to state laws and the Constitution, the governor has 60 calendar days to act, and the bill can be approved. It can be vetoed, as described in the second and third dot points with the arrows. It can be vetoed, and if there are changes made, it goes back to the chambers, and that's the start of the veto session.
So now that we have kind of the basics, that background information that we wanted to share, we're going to take some time now to take a bit of a deep dive into the legislative initiatives that were proposed this year. And we're going to start with the Ombudsman Program legislative initiatives, and I'll cover those, and then I'll turn it back over to Karen to talk about the initiatives from the Illinois Department on Aging. So we had 5 legislative initiatives that we were working on this year. That was a lot for us. I'm not sure that we will ever try to do 5 again, but you never know. It kept things really exciting this spring for us. We can definitely say that. So the first one that I wanted to talk about was Senate Bill 2715, and this is a bill that amends the Illinois Act on the Aging. And what we were trying to do with this bill is to make sure it's really clear how ombudsman records that have complainant information and resident information are protected. And so we essentially, we didn't mirror the language at the federal level, but we made it clear that ombudsman records that have resident or complainant information will not be released, cannot be released unless there is a lawful subpoena or permission from the state ombudsman, which is essentially what the federal law says in how the rules and law in the Older Americans Act are set up. But it wasn't as clear in the state law. And so we wanted to make sure that it was clear in state law, that there wasn't confusion. We had a situation in the past with someone trying to use the Freedom of Information Act request to get confidential resident records. And so we just worked on this language to clear that up.
And I would point out that that's a really important concept as an attorney, because individuals who interact with all of the human service programs don't necessarily have any idea about how the Freedom of Information Act works, because it has a presumption that all public records are accessible unless there are certain exceptions. And those exceptions are intended to protect your individual personal records. So this is very important, and I really commend the Ombudsman program for getting this clarification out there, because everyone has a right to confidentiality that ensures that they can express their needs in the best way possible. And I notice that Mary M. has her hand up.
Mary, you can go ahead and unmute yourself and ask your question. And anybody, if you have a question, please do what Mary did, or you can type it in the chat.
Sorry, I had to get to my mute button. I apologize.
That's okay.
Just to clarify, I think this is true, but when this was being described, you guys said that it was only the ombudsman could release the information, but can't the resident do it as well?
So they're ombudsman records. So a resident could request to have their records released, and they would make that request to the state ombudsman, who would then grant that request.
But they can't, the resident can't ask that it be released to another party?
Yeah, but they have to ask the state ombudsman to do it. So,
okay. Yeah. Okay.
Yeah.
Yeah, and so Mary, I think maybe the clarification would be like in a nursing home, those records are considered your records if you live in the nursing home. When the ombudsman take their own documentation regarding any casework that they're doing, those records are actually considered the state ombudsman program records, not the individual records specifically. So that's why the state ombudsman is the one who releases that information.
No, makes sense. Thank you.
Okay, so the next bill that we're going to talk about is Senate Bill 2957. And what we were doing with this bill is making sure it was clear that ombudsmen have access to facility incident reports. So anytime there is an incident in a nursing home, so maybe a accident or an injury with unknown origin, or there is a fight, something like that takes place, a home has to do what we call the facility incident report. And that report gets sent to the Illinois Department of Public Health as well. And so we wanted to make sure it was clear that the ombudsman can access that report if we have permission from the resident or resident representative as appropriate. And so we just added clarifying language around that. The other thing is the federal regulations related to the ombudsman program clarify that we can get consent orally, visually, and through the use of auxiliary aids and services, as long as those are contemporaneously documented by an ombudsman. So basically, if someone uses some sort of auxiliary aid to give us consent, the ombudsman has to document that, but that is a way that the ombudsman can receive consent to take action or to request records or whatever the resident's asking us to do. Prior to this change, I think it was just oral or verbal. And so we wanted to make sure that we were matching what was in the federal regulations.
And Jess, if I could just speak to the need for this, as many times as ombudsman people, an ombudsman might be learning from a resident that an incident happened in the building. And so that would have been needed to be reported to the regulatory body, Illinois Department of Public Health. And so we can ask the building, did you file that incident report? And sometimes they may say yes, but we never can make sure that that really happened. So that's where we can, unless we've reached out to Illinois Department of Public Health, and we want to make sure that we're working with the buildings directly. So that way, then we can ask them for that copy if we need to have that copy to be able to read the whole thing in full and be able to see if there's any assistance, any systemic things, anything that we may be able to help either the resident directly or the building collectively to be able to address those issues that may be happening related to those incidents. So a little bit of motive for why.
Thanks, Lee. The next bill that was passed by both houses is House Bill, or both chambers, is House Bill 4427. Sorry, I thought it was on to the next one. And this bill, what it does is last year, the Assisted Living and Shared Housing Advisory Board was created. And as we were looking at that and discussing it, we realized there was no guaranteed resident representation. So there are other similar advisory boards and other types of licensure. So the nursing homes have one. And in those other boards, there are residents the board is required to have residents as members, as voting members of the board. And so this year, once we noticed that, unfortunately, it wasn't until this year, we did work to make sure that at least one voting member is a current or former resident of assisted living or shared housing establishment. So that's what House Bill 4427 did. While there are many other individuals who will be part of this advisory board that have a lot of knowledge, we felt that that first person experience of someone who has actually lived in assisted living or is currently living in assisted living is really important. And we wanted to make sure that direct voice was part of this board. And so that's what House Bill 4427 does, or will do, if and when it's signed by the governor. The next one that we have here is House Bill 5095. And I want to start out by making sure that I emphasize that this is specific to nursing homes with what is called distinct part. So I know distinct part is not something that everyone's familiar with. So I want to just take a moment to talk about what distinct part means. So a nursing home that has a distinct part essentially has a limited number of beds that are certified for Medicaid. So let's say there's a home that has 100 total beds inside of it, but only 12 of those beds are certified for Medicaid. Those 12 beds are the distinct part. If a resident's Medicare days end and all of those 12 Medicaid beds are full, the resident's left with two options. They either have to pay privately or they have to find somewhere else to live. And for individuals in this situation, sometimes the federal law only guarantees them 2-day notification. So having only 2 days to figure out where you're going to go next can be problematic for residents who find themselves in that situation. Another kind of big picture piece of this is when we think about Medicare, residents can receive up to 100 days of Medicare coverage in a benefit period. However, it's quite common for people to get less than 100 days. And so the goal of this was to make sure that if someone's Medicare is going to end earlier than that 100 days, that they have some notice, they have some time to figure out where they're going to go next, what they're going to do next. And so what we did is we actually had a lot of negotiation with the nursing home industry, and we got that minimum up to 5 days notification. While it's not maybe where we had hoped to be at, it's definitely holding Illinois homes to a higher standard to better protect residents' rights than the 2 days, which is what is required as the minimum at the federal level.
I'd like to jump in just to indicate that sometimes it's a legislative win when you just get something on the book, so to speak, and get everybody reoriented to a new normal. And then a year or two down the road, you can again get a second bite of the apple and advocate for additional changes. Just because this is what the law says it's going to be when this bill is signed, which is what we all hope, doesn't mean it will always stay that way. It is a process, and it is an ongoing process.
We had a lot of discussion, not just with this bill, with a lot of our bills is, we don't have the cure-all for all the problems related to resident rights. So a lot of our discussions included the idea of we're trying to make progress. We're trying to move the needle forward. We're trying to take baby steps. And thanks for that, Karen.
And there is a question in the chat regarding House Bill 5095. You referenced Medicaid at one point. Did you mean Medicare?
I didn't. So oftentimes with distinct part, you will have 100-day, I gave the example of 100 beds in a home, okay? And so likely, what did I say, 12 of those were Medicaid. So it's possible that all 100 are certified for Medicare, but only 12 of those are certified for Medicaid. So if those 12 Medicaid beds are full, and that person is going off Medicare and needs to go on to Medicaid, there's no Medicaid bed available because those 12 Medicaid beds are full. So it's a little bit confusing. I totally get it. So I'm glad you asked that question, but it really is, when we're talking distinct part in the situation that we're speaking to with what this bill was trying to address, you're going off Medicare, but there are no Medicaid beds available. Most nursing homes have all of their beds certified as both Medicare and Medicaid. They don't have distinct parts, so this isn't an issue. But there are some homes in Illinois that do have distinct part where this is really problematic. And that's what this was going at, not a home that is dually certified, you know, for both Medicare and Medicaid and all of their beds. This is for those that have that limited number of Medicaid, the beds that are Medicaid.
And then there was another question about, it says that the question is, isn't the notice 30 days in the Ombudsman Resident Rights Handbook?
Okay, so that's another great question. So all of the other discharges related to nursing homes, actually it is, well, we're talking Medicare and Medicaid facilities here. So yes, it's 30 days. If a nursing home doesn't take Medicare or Medicaid dollars, then it's actually a 21-day notice. But because most of our homes take Medicare and Medicaid, or one or the other, they do have a 30-day notice of facility-initiated discharge. However, distinct part is unique, and because of the distinct part rules, it is allowable to give that notification. If someone is going to be in distinct part, they have to be notified before, like when they come into the building. The home has to educate them that the home is distinct part. This is the number of Medicaid beds we have. They're getting that education up front so that they know when their Medicaid days run out, they're going to have to be in this unique situation where if there's not a Medicaid bed available, they'll have to pay privately through a secondary insurance, or they'll have to find somewhere else to live. So this is the one caveat to that 30-day notice. Our initial bill actually tried to get the 30-day notice. And again, in the negotiating back and forth, it really put, and we recognize that would put homes in a situation where they likely wouldn't get paid for that time. And so it was negotiating again with the industry to build more protection for the residents than what that 2 days is, but not put the homes in a bad position of where they're having a bed with a body in it and they're not getting paid for it. You know, like if a resident's living there, they should get paid for the time that the resident is there.
And this series of questions is precisely the reason why it is so important that we have the Ombudsman program, because when you move from living independently at home into the different types of long-term care facilities, each facility has different rules that may come into play based on the licensure, and you can't be expected to learn everything overnight, notwithstanding the fact that when you are admitted, you're given this entire packet of information and disclaimers. So kudos for all the volunteers and the ombudsman who help, because it is very stressful when you don't quite know exactly what all your rights are. So thank you to my colleagues in the Ombudsman program.
Thank you for that,
There
Karen.
was another question. If you could please clarify then what's new in the bill? What's the new thing that happened here?
Yes. So it was a 2-day notification. The federal government requires that you be given a 2-day notification. And so we've increased that to 5 days. So you're not finding out on Wednesday that you have to be out by Friday at 4 p.m. right now. You're finding out on Monday that you have to be out by Saturday. So again, it's not where we wanted to be, but it is building more protection than what was in the original language.
Thank you.
Okay, so those 4 bills that I just spoke of passed both chambers and are, if you look them up, the status that you would see on that ilga.gov website shows, what does it say? Pending governor's signature or waiting governor's signature, something like that. They're on the essentially We say they're on the governor's desk. We're waiting for him to sign them. The last bill that I'm going to speak about is House Bill 5051. This bill was initially introduced as House Bill 5012, and the companion bill was Senate Bill 3723. We don't have time to go into it. If you would like to hear the story of how that all happened and why we magically ended up on House Bill 5151, reach out to me. I'm happy to share, but we don't have time to get into all of that. But essentially, our language is now sitting in an amendment that was put in on the Senate. We got it back over to the House, and the House didn't take any action before they adjourned for the summer. And so we are hopeful that this bill will resurface and there will be movement during veto session, but we're not sure. And if that doesn't happen during veto session, then we will likely take this language and try and reintroduce it next legislative session. We'll have to start over and get it past both chambers and then to the governor's desk. But our hope is that it maybe makes it out during veto session. So House Bill 5151 was it's a big bill. There's a lot of changes, but they all, for the most part, relate to involuntary transfer and discharge when we talk nursing home, or termination of residency when we're talking the Assisted Living and Shared Housing Act. So on the slide, you can see those steps, or those bullets down there, I guess they're arrows, talk about the changes that this bill would make in terms of the Assisted Living and Shared Housing Act. So one of the things it would require is that the assisted living home would notify the resident and the resident's representative if there's a significant change in the resident's condition that affects the home's ability to meet the resident's needs. We have situations sometimes where it may be that the resident is declining. The resident is maybe not appropriate for the level of care provided in the assisted living establishment. And what this change does to the law is it makes the home responsible for letting the resident know, letting the family member know, these changes are affecting our ability to meet your needs, and it may end up leading to you needing to go somewhere else. Currently, if a home issues a facility-initiated termination of residency, so a discharge notice, essentially, if it's assisted living, they have to notify the resident, they have to notify the ombudsman, but they're not required to notify the Illinois Department of Public Health. So that was added to this language. So we have a typical discharge process or termination of residency process that's followed, which is typically a 30-day notice, a right to appeal. But there are allowable emergency notices or emergency discharges. And one of the things that we clarified is a home can't say it's an emergency if the resident's doctor, the home's manager or administrator, and the home's director of nursing. So basically what this is going after is hospital dumping. So a home sends the resident to the hospital and says, we can't take them back. It was an emergency. They're no longer in the home. And this is saying that they can't follow through with an emergency discharge if it wouldn't create imminent danger or serious harm to a resident, or that emergency could be negated if there were changes in activities, healthcare, personal care, or room accommodations. Now, we're not saying we expect a home to do something that's outside of their license. It's not that at all. But it's very much, you can't just say, well, I don't like that person, they're not coming back. We got them out of here. It was an emergency, but now they're not coming back. The doctor, the administrator, and the DON have to say it would create an imminent danger or serious harm would come to residents if we took that person back. If it's not that level, because the other thing is if somebody's not appropriate, if they are going to create a situation of imminent danger, they shouldn't go back, right? So we're trying to create checks and balances to make sure that if they should be back, that they're allowed to come back. And if they shouldn't be back, these people would say so. And then, we'd have to address what's taking place, where is an appropriate place. The other thing it clarifies that The home can be fined if they refuse to readmit the resident after there's been a hearing and the judge ruled in favor of the resident. So the home issues a notice of discharge, the resident appeals it, there's a hearing with an administrative law judge. The administrative law judge says, no, you can't kick them out. They should stay here. And the home says, we don't care what you say. We're not taking them back. In that situation, this bill allows for a fine to be assessed. We did not specify the fine amount in for the assisted living side of this. That's something that the Illinois Department of Public Health would determine during the rulemaking process. And then the last item here on the page is that it would require establishments to give a copy of residents' rights that are prepared by the State Ombudsman program. We do that for all of the other license types that we cover, I think, or most of them anyway, but not assisted living. So we added that in here as well. House Bill 5151 also made changes to the Nursing Home Care, or would make changes if it passed and was signed, to the Nursing Home Care Act. And on this side of it, we did end up putting a fine amount if a home refuses to readmit a resident after an administrative law judge rules in favor of the resident at a discharge hearing. We were not going to put a fine. The sponsor wanted us to specify a fine amount. And so we recognize that $2,500 is not a very high fine, but it's something. And so, again, that's one of those baby step areas of negotiation that was landed on. It requires the nursing home to provide notice to the Illinois Department of Public Health that a resident has been readmitted following administrative law judge's ruling. So there's a discharge hearing. The judge rules in favor of the resident for the resident to stay. The home then says, yep, they're in our building. We've readmitted them. In addition to that, that third arrow there allows Illinois Department of Public Health to take that notification into consideration if they get a complaint about something related to that individual. It also provides for a 30-day notice of transfer or discharge rather than 21 days to be consistent. So I brought that up earlier talking about the previous bill. Right now in the Nursing Home Care Act, it says 21 days. Now, federal law supersedes state law, which is why it's 30 days for most of our nursing homes, but there are a handful of nursing homes where it is just 21 days. And so this would increase it to 30 days across the board. And lastly, it requires a notice of discharge to be sent to a managed care organization when applicable. We've heard of some situations where a resident received a discharge notice and maybe was transferred out, and their managed care organization, who's essentially their insurance company, who has responsibilities to contact them regularly, didn't know they moved. And so if there's a discharge hearing, a discharge notice, I mean, that the managed care organization has to be notified as well.
There is a question in the chat regarding if this is 5151 is about assisted livings or supportive livings or all long-term care.
Okay, so the first slide related to 5151 is just assisted living and shared housing, so not supportive living. Assisted living and shared housing. I'm going to say, like, the general way to think of shared housing is assisted living small. That's not exactly how it works, but for the most part, if you think of what assisted living is, shared housing tends to be the same thing, but fewer residents in the home than assisted living, but again, not always. The second slide is specific to nursing homes. Did that clarify it? Hopefully.
And it is very common in legislation to, when it's dealing with an overall topic, which is long-term care, to open up several different related acts and provide amendments to different acts in one bill. They have to have a shared point of commonality.
That helped clear it up.
This one was discharges, right? So because we were going after this idea of facility-initiated discharges or termination of residency, that's the shared commonality. Any questions?
I think we're good.
Okay.
Please don't hesitate to put your questions in the chat, though, if you have any.
Apart from the initiatives pursued by the Ombudsman program, the Department on Aging itself also moved two major initiatives, one in the Senate for the Adult Protective Services program and one in the House for the Community Care program. And if we move to the next slide, Senate Bill 2799 is dealing with the Adult Protective Services program. And this bill is intended to address various responsibilities of the department so that it can better respond to self-neglect cases. Self-neglect cases are the most rapidly increasing type of case that is being investigated under the Adult Protective Services program. These cases require more intensive work than investigations into other types of abuse allegations. So this bill is intended to allow for the more proactive provision of services that will help mitigate risk and allow for more efficient timelines. Another aspect that it deals with is going into the Open Meetings Act, because prior to this bill, the definition of public body included the Illinois Fatality Review Team Advisory Council. And while open meetings is part of the concept of good government, the specific type of sensitive work involved in investigating fatality reviews with the lessons we've learned coming out of the pandemic indicated that it could be challenging to get the in-person quorum requirement so that the legal requirements of work for a public body could be met. So if this bill ends up being signed into law, it should make it easier for fatality review teams to do its work. And then, as always the case, other related changes were made for adult protective services, but the key points of this bill was dealing with self-neglect. And moving on to the next slide for House Bill 4346. This is another bill that amends the Illinois Act on the Aging, which is the enabling statute for the community care program. And this initiative is largely aimed at cleaning up outdated provisions. It's intended to better align the enabling statutes with updates that have been made over time because the community care program also operates in part as a Medicaid waiver, and that allows the state of Illinois to get reimbursement for some percentage of the services to Medicaid eligible individuals, so more money goes a little bit further. There are specific provisions to improve the definition for the term greatest social need. That is a key term for older American services because there's never enough to go along. One of the things we learned at our last resident meeting was about the annual award for the Senior Hall of Fame. There will be language tweaked to address the awards when no one is nominated in a certain category. And then, as is all the case, it is addressing rate changes for the enhanced rate for those in-home service providers under the community care program that offer health insurance to direct service workers. And last but not least, it makes a legal change to clarify that all final administrative decisions of the department are going to be subject to judicial review, and that will make it easier for people who are dissatisfied with decisions to seek legal recourse through the various appellate measures. And if we move over to the next slide, Jess and I will again have a back and forth dialogue. I wanted to make it clear that while the department engaged in legislative initiatives and the ombudsman engaged in legislative initiatives, each and every one of us as an adult has an opportunity to express our opinions to elected officials and representatives of public bodies. And if you are interested, I have 2 resources listed, one of which is a toolkit by National Consumer Voice, and the other one is on the National Council on Aging. And you can do that by setting up an in-person visit, by leaving a phone message, or writing. And it's never too early to start. One of the bills that's out there in the 466, I believe, was from school children as a civics education movement. They have a bill that passed both houses that would create, I think it's called the giant puffball, that will become the official state fungi if it's signed into law. And many of you at different points in your life, whether you were objectively aware of it or not, have engaged in advocacy efforts. Maybe you were part of the civil rights movement when you were younger. Maybe you engaged in political rallies regarding the Vietnam era. There's all sorts of things. Maybe you were a member of a union and attended rallies. So each and every one of us has a voice, and we can make it heard. It's just Jessica has experience in a professional setting with the Ombudsman program. Are there anything that you've learned about engaging in this type of advocacy work, Jessica?
Karen, I think one of the biggest things that stands out to me is the idea that I think sometimes we just assume that other people are making those phone calls or sending those letters and talking to legislators and their staff. There are times when they're not hearing from very many people at all. So it does make a difference when you take the time to reach out to them. They're there to represent you. They want to know what their constituents want. And there are legislative proposals that are made or bills introduced, I guess is what I'll say, because constituents have contacted their representatives, their legislators, to say, this is a problem. How can you help me? What can you do about this problem? So it really does make a difference. Over the years, I think back to in the early 2000s, early in my career, I was a regional ombudsman at the time, but we really hit the state capitol, the halls of the Capitol hard, advocating for some legislative changes. And we went door to door to door to the different senators and representatives' offices, educating them about why the bill that we were working on was important to their constituents. So it's one thing for the ombudsman to reach out to a legislator and talk to them, but it adds another layer of importance when the legislators are hearing directly from their constituents as to why this particular bill would impact them directly. So I can't stress enough the importance of doing that. And as I'm speaking about the legislators and their staff, I have to give a shout out to the work that they do. We worked very closely with several representatives and several senators this year, the sponsors of our legislation. For each of our legislative initiatives, we actually introduced it in both chambers. So we had a House bill and a companion Senate bill. So we were working with 10 separate individuals to get this legislation started, and then others signed on as co-sponsors. And there was a lot of work put into this, not just by the senators and their representatives, but their staff also. So for those of you that are maybe listening in or watching later that work for one of our legislators, or if you're a legislative yourself, thank you, because it's a lot of work. Just a little snippet that I get to see, it's a lot of work. And so we appreciate being able to partner with the different legislators and their staffers to improve the laws that we already have.
And I have to say,
and the members of the General Assembly over the last few years dealing with the pandemic have worked really hard to push additional funding out into the network. for a wide variety of options to help older adults living in community, living in long-term care settings. It takes a village, and it takes elected officials doing their part, and they really have done yeoman's work. We all have, because we got to live through it.
And I have to say, as this role working for the state through the Ombudsman's office, we do get legislative liaisons reaching out to us regarding some of their constituents. Because their constituents are calling them and saying, I have an issue with this long-term care community. Can somebody please reach out and talk to me? And because people sometimes don't know where to turn. And so it's helpful when the legislator is aware of our program, because then they forward that on to us, so that we can then, being those people that work with those long-term care communities, we could help be that person to assist their constituent. So that can really be a really great opportunity to increase that awareness as well. We did get a question in the chat as well. Any plans next year to increase the personal needs allowance for long-term care facility residents, maybe to tie to the cost of living increases?
So that's something that is being discussed. I don't know what, I know that there was a bill that was doing that this year, and I honestly don't remember if it got rolled into something or if it ended up not passing.
I don't think it passed. I don't think it made it out of committee. It was maybe Senator Chapin Rose. And as far as I saw, unless it made it into the BIMP, this is Amy, and thank you for the presentation today. But last I saw the standalone legislation that Senator Chapin Rose had, and I think somebody in the Ombudsman's program, I think he leans on them, which is great. I was really impressed to see that he, I think, reaches out to someone that covers the Champaign area. But as far as I saw, the standalone legislation didn't even get assigned, I don't think, to committee, or didn't make it out of committee.
Okay.
Amy, I did know that there was a provision for the personal needs allowance and supportive living facilities, and that is moving, but again, it requires federal action, so it's not a done deal as of yet.
I'm sorry. Can you say that again?
There is a measure addressing the personal need allowance and supporting living facilities, and that did move this session. It is tied into something else, and I'll see if I can find it while the next person that I inadvertently interrupted puts their comments back out there.
Oh, and this is Roberta from Department of Aging. We think it was in the BIMP. It was in the BIMP.
So really? For the supportive living increase to 120, Roberta, is that what you're talking about?
Gloria's looking it up right now. Yes.
Okay. It was either in the BIMP or in the Omnibus Medicaid.
It's now Public Act 103-593.
But I think there were two different. I think there was one that bumped up things to 120, but then there was also legislation so you wouldn't have to keep on going back, and it would just tie it to cost of living and that. So it's two different things, right?
Correct.
So
and I haven't seen the one about the cost of living yet.
So to be clear, this is Ashley Snavely with Illinois Healthcare Association. So yes, it was in the Medicaid work group bill that has been signed into law. You are correct. I know AALC was primarily working on this, but it is not tied to cost of living. It increased to 120 for supportive living members. And then last year we increased it for skilled members up to $60. So 60 for skilled, 60 for DD, and then 120 for supportive living. And all of it will be in law now. And then as someone mentioned, there is subject to federal approval on the SLIP side.
Thank you, Ashley. That clears it up. And okay, so 60 for skilled and DD, and then 120 for assisted living. And all subject to federal approval, but nothing. But the legislation that Chapin Rose had to tie it to cost of living, so you don't have to keep on coming at it. That basically didn't go anywhere, right, Ashley?
Correct. The cost of living, and it's for supportive living, not assisted living.
Correct. Yep. Got it. Okay. Thank you.
I know there was legislation out there to dealing with the personal needs allowance for individuals who receive supplemental security income, but I don't believe that that made it out both houses. But that's an issue that I know is different organizations and bodies are aware of that. So maybe something to look forward to in the future.
If I could answer that, that was our bill.
Okay.
There's actually a couple of them. We filed one. Representative Weber filed one earlier this year, and mostly because I worked for nursing homes when I was 20, and when I was 20 through 24, it was $25 for personal needs allowance. I'm 58, so do the math, and now it's $30 for personal needs. Fortunately, the developmentally disabled get, I think, 70 right now, and they're trying to get that up to 90. Can you guys hear me?
Yeah.
Okay. So they're trying to get up to 90. So that was the reason why we filed the bill is, we did the math. And even if you had an inflation, it's these people are being treated substandard. And to watch, these people with Medicaid, it's just, it's not possible.
It's heartbreaking.
$30. I mean, you can't buy underwear, socks, and some of these folks, they don't have family. So whatever they have because somebody gave it to them. So yes, and it went nowhere. We weren't able to get any of our bills even barely heard in committee, which is just politics, which is what I don't like about this job. That was all.
I wish we all had magic wands, right?
I wish we could all actually work together and act like adults.
Yeah, but I have to say,
do.
I've been very impressed with our legislation this year, that there were so many issues that came forward in the aging path. I think that the pandemic actually did raise a very big awareness out of this horrible, horrible event. We had some good things that happened, and that we increased public awareness of the need to really address legislatively what we need to do to protect those people that we're tasked with caring for as a state, as a long-term care community, as an ombudsman, and as family members. So I think that this is, I think we're doing some good things collectively. So I think we do need to recognize that as well. And there's so many people on this call today. We've got family members, we've got residents, we do have representation of our state legislators, and we've got some trade associations. So it's absolutely wonderful that we can all come together to hear this great conversation about the movement that, working together as a team, we've been able to accomplish some things this year for the betterment of those that live in long-term care.
And Lee, as you're talking, one thing that I think is important to note, I don't remember which bill didn't, but most of our bills passed their respective chambers unanimously. So we didn't see that political divide of Democrats versus Republicans, or, I think people on both sides of the aisle could see the benefit of what we were trying to do for residents. And that was really important to us to see.
That's really great. So with that, we are at our mark. I'm going to go ahead and I'm going to stop the recording right now. But if anybody still does have any questions that they'd like to ask, we will be staying on just to make sure that if anybody has anything, that they could go ahead and do that. So if I can find the recording button, I will go ahead